The second section of your training deals with initiating claims. The most frequent type of injury claims you will encounter are those for a traumatic injury. A traumatic injury is defined as a wound or other condition caused by external forces, including physical stress and strain. The injury should be identifiable as to time and place of occurrence and member or function of the body affected. Further, it must be caused by a specific event or incident or series of events or incidents within a single work shift. It is this last criterion that sets apart a traumatic injury from an occupational disease. Traumatic injuries are easy to identify. Some common examples are when an employee slips and falls and breaks a bone, or after one day of moving boxes, an employee strains his back. Each of these injuries can be traced to a job-related event or series of events occurring within a single workday or shift. To give notice of a traumatic injury, Form CA-1, Federal Employees Notice of Traumatic Injury and Claim for Continuation of Pay, must be completed by either the injured employee or someone acting on his or her behalf. The second type of injury that you will process will be for an occupational disease. An occupational disease is defined as a condition produced in the work environment over a period longer than one workday or shift. It may result from systemic infection, repeated stress, or other continuing conditions of the work environment. To qualify as a disease, the injury must be caused by exposure or activities on at least 2 days. It is this last element which sets an occupational disease apart from a traumatic injury. As an example, federal employees who experience wrist and hand symptoms that they attribute to repeated daily typing should file a claim for occupational disease. Another example would be employees exposed to hazardous noise levels who experience noise-induced hearing loss. These workers would also claim an occupational disease as the exposure exceeded one work shift. To file a claim for an occupational disease injury, Form CA-2, Notice of Occupational Disease and Claim for Compensation must be completed by the employee or someone acting on his or her behalf. You may encounter situations where an injured employee experiences a spontaneous return or increase of disability due to a previous injury or occupational disease without intervening cause. A recurrence of disability differs from a new injury. With a recurrence, no event other than the previous injury accounts for the disability. A recurrence of medical condition is defined as a documented need for further medical treatment after release from treatment for the accepted condition or injury when there is no accompanying work stoppage. In such situations, the injured worker will file a CA-2A, Notice of Employee's Recurrence of Disability. In the event of an employee's work-related death, the supervisor must immediately notify OWCP by completing Form CA-6, Official Superior's Report of Employee's Death. The supervisor then contacts any survivors, provides them with claim forms, and helps them prepare the claim. The forms are submitted to OWCP even if a disability claim was previously filed and benefits were paid. Continuation of benefits is not automatic, as it must be shown that the death resulted from the same condition for which the disability claim was accepted. The survivors of a deceased employee use Form CA-5 to submit claims for death benefits. The survivor completes the front of the appropriate form. Then, the attending physician completes the medical report on the reverse and forwards it to OWCP. It is helpful if the submission includes a copy of the death certificate, since this is needed to process the claim. If a spouse is making a claim, the submission should also include a certified marriage certificate. If the decedent or spouse was formerly married, a copy of any divorce or annulment decree should be included. Finally, the submission should include certified copies of birth certificates of any children for whom claim is made. All of this documentation can be submitted after the CA-5 has been filed. However, Submitting it along with the CA-5 speeds up the processing of the claim. Regardless of the type of injury claimed, there are certain steps that the supervisor, or you as the injury compensation specialist, must follow. Review the front of the form for completeness and accuracy, and assist the employee in correcting any deficiencies found. Complete and sign the reverse of the form, including a telephone number in case OWCP staff has questions about the injury. Also, insert the appropriate codes on both the front and back of the form for occupation, type and source of injury, agency identification, and location of duty station by zip code. Pay attention to blocks 30 and 31 on Form CA-1 and blocks 33 and 34 on Form CA-2. This is where you are asked to identify other parties who may be responsible for the injury. This frequently occurs when employees are injured using public modes of travel, are involved in automobile accidents, or when the injury occurs in a non-federal facility. Refer to the publication CA-810 for a description of the type and source of injury codes and their use. Sign the receipt attached to the form and give it and a copy of the entire form to the employee. Now that you have the appropriate claim form, it must be properly routed. If your agency participates in electronic submission, consult with your agency's program manager for detailed instructions concerning submission of claims. There are certain circumstances when there is no need to forward the claim to OWCP. If your employee does not lose time from work beyond the date of injury and medical expenses are not incurred, retain the CA-1 in the employee's medical file. However, all CA-2s, CA-2As, and CA-5s must be submitted to OWCP regardless of the circumstances. If medical treatment is required for a traumatic injury, the supervisor must provide the injured worker with a completed Form CA-16, Authorization for Examination and/or Treatment. Form CA-16 authorizes an injured employee to obtain immediate examination and/or treatment from a physician of their choice for an on-the-job injury. A CA-16 carries a promise of payment, and OWCP honors any medical bill from the designated provider for a period of up to 60 days. If the supervisor doubts whether the employee's condition is related to the employment, he or she must indicate this on Form CA-16. The supervisor may not, however, refuse to issue the form for this reason. The only time a CA-16 can be withheld is if more than a week has passed from the date of injury. Form CA-16 is not issued in claims for occupational disease or recurrence, and an employee may not authorize his or her own treatment. The injured worker is entitled to the initial selection of the physician to provide treatment. The provider must meet the definition of physician under the FECA and must not have been excluded from payment under the program. Physicians employed by or under contract to the agency may examine the employee at the agency's facility in accordance with OPM regulations. However, the employee's choice of physician must be honored, and treatment by the employee's physician must not be delayed for the purpose of obtaining an agency-directed medical examination.